I'm Joey Hargis, and I'll be presenting the cases for today in today's public hearing. I would ask at this time everyone please either put on their cell phones on silent or vibrate so they don't go off and disrupt today's meeting. The board would appreciate it. The procedure will be to introduce the case record as the Codes Department has it, and we'll do that on the wall here by means of a PowerPoint presentation. We'll present any letters we've received in support or opposition to a particular case, as well as any correspondence from other metro agencies. At the conclusion of my presentation, the applicants will come first to the table here. I've got 3 seats for you, along with any persons in support. Identify yourselves and make your presentation. After the applicant comes up, if there's opposition present, we'll hear from those parties opposed, and they'll come up after. And then, not working? Not at all? Sorry, we're having mic trouble. Mics are fully on, so must be you, sir. So I'm going to give you something to help you out there. I can't see, so we're in good shape there. Where was I? Let's see. All right. So first, the applicant will come first to the table, along with any persons in support, and then after the applicant comes up, the opposition will then come next. And then after the opposition speaks, the applicant does get a period for rebuttal. In the board's rules, if there is cases with opposition, each side of a case has 15 minutes, not per person, but that's per side. So if you have multiple folks who wish to speak today, be sure you divide your time up before you come up to this table. To your right of where you're sitting up on the countertop there is a clock that'll keep track of your time that you have remaining. It will run during your testimony. It will stop for any questions and answers to those questions. But once you're done answering the question, you get back into testimony, that clock will restart. The board will go through all cases set for public hearing today, and after each case, the board will discuss and vote on that case in front of you. The board is vested with the power to act on the cases as outlined in Section 1740-180 of the Metro Code of Law. The code requires that 4 members of this 7-member board be present to constitute a quorum. I have only 4 members present today. The code also requires that you have all 4 of these votes for your case to grant your approval. If you have a vote of, not a unanimous vote of some kind, 3, 4, 1 against, 2 for, 2 against, your case is automatically reset and re-advertised for the next available public hearing. That hearing currently scheduled for March the 19th. If, in the unlikely event today, I do have a 5th member shows up, and here's the case, and you still have a tie vote, meaning you don't have 4 votes, your case will be on our agenda for the next 30 days. And those members who participated can change their vote. Those members who did not participate are eligible at their discretion to come in and review the record and then participate should they wish to. But in the event, if I have 5, which I honestly do not believe I will today, I'll only have 4. And after 30 days, no one changes their vote, your case is deemed denied by operation of law. The applicant or any aggrieved property owner may request a rehearing of this board within 60 days of today's public hearing. Further, any applicant or aggrieved property owner may appeal this board's decision to Chancery or Circuit Court within the 60-day period. But once 60 days has elapsed, the board's decision is final, and no further action may be taken. If you're an applicant and your case is approved today, this is not the last step for you. You do need to follow up with the Codes Department to continue processing your permit. To obtain the permit for which you've applied, you have 2 years from today's date for this board's approval meaning you have 2 years from today to get that permit in your hand from the Codes Department for this approval to remain valid. But if you wait 2 years and a day and you then come down to the Codes Department and get your permit, you get to do this all over again. So do not delay on that. Mr. Chairman, I submit that all cases were filed in proper order. Applicants have been notified by certified mail as required by the code. All affected property owners within 300 feet of today's properties were notified, and a legal ad was published in the Tennessean. And this board allows elected officials, if present, to address the board before we begin today's public hearings. Are there any elected officials present who wish to address this board? Okay, seeing none, Mr. Chairman, we have several preliminary announcements, and it's get started on those. We had a case, I do not have it on the agenda from last time. It was Bank of America on Castleman. I do not have a quorum to deal with that case today. So that case was tied up on votes. By operation of your rules, 30 days will elapse. That case is deemed denied by operation of law. So it was a tie vote in that case of 3-3. I don't have the members present to ask them to change their vote one way or the other. But by our rules, that case will fail today for failure to receive 4 votes in 30 days. So case, and I apologize, not listed in the agenda there on Richard Jones Road, the Bank of America will be denied and an order will be entered accordingly in that case. Let's see here. The next preliminary announcement I have will deal with the case at the top of page 3, case 2015-15, Metropolitan Government, the appellant for the proposed fire station at 1630 Harding Place. Member Harper, David Harper, is going to have to recuse himself from this case. Because he recuses himself from case 15, this case loses a quorum. As I talked about, you must have 4 members to hear any case before this board. He is not eligible to participate and will withdraw from this case, leaving just 3 folks present. That case will automatically, by rule, be deferred to the next hearing. So if you're here for the case on the fire station on Harding, it will not be heard today. It will be 2 weeks from today, the first case on our agenda for the February the 19th. At that meeting, all the members but for Mr. Harper will be eligible to participate. And I do apologize for the lack of a quorum there. So if you're here for case 15, that case is deferred automatically and will be heard 2 weeks from today. Same time, 1 o'clock, right here, and it will be the first case heard on that agenda. And Mr. Chairman, that is all of preliminary procedural announcements I have. The board does have a consent agenda. And prior to the day's hearing, a board member reviews the record in each case that remains on our agenda. And if, in the opinion of the board member, the applicant meets the criteria for the application they've requested and they feel that testimony would not alter the material facts, they recommend the case to the remainder of the board for approval. I'll now call out those cases that have been recommended for consent. And if there's any parties here who have questions or in opposition to any of the case numbers that I read, please raise your hand. Be sure I see you, and we'll pull that from the consent agenda. I'll offer you an opportunity, if it's just questions, to meet up with the applicants, perhaps, and step outside the room and discuss. If it's opposition, then we'll hear its case in the regular order as listed on our agenda. The following are the cases recommended for the consent agenda. The first case being case 2015-8, Mr. Michael Shaw, the appellant, the Whaley Family LLC, owners of the property at 2211 Castleman Drive, requesting a variance in street setbacks in R20 to construct a duplex. Are there any parties present opposed to case 8 on page 1? Mr. Chairman, seeing none. This case actually deferred from our last meeting, was on the consent agenda then. The applicant and I discussed after the hearing opened, we had some numbers wrong on their site plan. That approval by this board on those wrong numbers would trigger him to have to come back and ask for a new variance, so we deferred it, got his numbers corrected, and the plan itself is unchanged pictorially, but the numbers listed on the plan are now correct. And so Mr. Whitson recommends that case to the remainder of you all for consent. The next case recommended for consent by Mr. Whitson, and again, as talked about, if you're opposed to any of these cases, please raise your hand. Case page 2, the middle of page 2, case 2015-11, Focus Builders, 157 Cheek Road, requesting a variance in the street setback to construct a new single-family residence. Any parties with questions or concerns? Okay, we'll hear. Have you all had a chance to talk with the applicant? Okay, all right. We'll hear that case in its regular order on this list. The next case recommended for the consent agenda is case 2015-17. That will be at the bottom of page 3, the Stevenson Development LLC. The item A appeal in this case has been withdrawn by the parties. This is a variance case in the spacing of digital billboard from residential zoning. This existing billboard already has LED on the panel itself. This would be a change of the remaining face of that panel to LED. Are there any parties present opposed to case 17 on 3814 Charlotte Avenue? Mr. Chairman, seeing none, this case you've recommended for consent agenda, case 17. Top of page 4 now. The next case recommended for consent, case 2015-18, Mrs. Miriam Muhammad, the appellant and owner of the property located at 5747 Mountain View Road, requesting a variance in the AR28 district to install a solid fence. Are there any parties present opposed to case 18? Mr. Chairman, seeing none. The applicant had originally applied to this board and has been working with Public Works on construction of a fence. To her defense, she actually, unlike 99.9% of the people who build fences, came to our office and sought our counsel first, and unfortunately we had our descriptions crossed on the exact location of her front property line. We withdrew that first case. She talked with Public Works and has that line set, and we'll be working with them on getting that fence moved back. But you all recommended that case for the consent agenda, subject to her and Public Works agreeing to the location of that fence to avoid any visibility issues. Finally, the next case recommended for consent, case 2015-19, Mr. Jason Bachman, the appellant owner of the property located at 4901 Nebraska Avenue, requesting a variance in the street setback in RS 7.5 to construct a new single-family residence. Any parties present or opposed to case 19 at 4901 Nebraska Avenue? Mr. Chairman, seeing none, there is across this property, and I'll get slightly ahead of myself, case 20 as well, a large sanitary sewer easement that dissects this property, and that is the hardship that necessitates a need for variance in case 19. Also, additionally, case 20 is recommended for the consent agenda by Chairman Whitson under the same hardship. They are joining properties. Any parties present opposed to case 20? Mr. Chairman, I see none. That is your consent agenda, recapping those recommended for consent: 8, 17, 18, 19, and 20.
So we have a motion. Is there a second?
Second.
Got a second. Motion second. All in favor?
Aye.
Passes.
If you're here for the cases that I've called, case 8, 17, 18, 19, and 20, you are approved. You are free to go. Again, as I talked about, please follow up with the Codes Department beginning on Monday to discuss permitting. Ms. Muhammad, you and I will talk after Public Works, as we discussed prior to the hearing. We'll talk about once Public Works sets your fence location. Just come by and see me after that. Okay.
I don't need anything in writing as of now.
You will receive something from us. Yes, ma'am. Thank you for coming. Yes, sir. And, Mr. Chairman, the legal counsel would like to make an announcement with your permission regarding case that.
Mr. Chairman, my name is Tom White. I wanted to bring to the board's attention one matter. I've been engaged for several months with respect to the neighbors that were down here on the case involving the Metro Fire Hall, which is the one at the top of page 3. And I have met with those folks for many months, again today with the fire marshal. And that matter is bumped off until 2 weeks, or at least till the 19th. I was contacted today with respect to another matter on the agenda, which is on page 2. And that's a matter where I said just was contacted today. It's Focus Builders, case 2015-011. I did not know whether there would or not be opposition to it. I just saw that some people raised their hands. I'd like to ask that I be able to go out in the hall and talk with those folks, see if there's something that can be resolved. If not, I may need to ask that to be deferred until the 19th when the other matter's heard here as well. So I just wanted to give you that announcement at the front end. Hadn't met these folks, only met my client a few hours ago. So I'd like to be asked to be excused to step out and talk about that.
That'd be fine. So there's a motion to move 011 to the heel of the agenda.
Second.
Got a motion, got a second. All in favor?
Aye.
Aye. Passes.
Thank you. I'll step out. Thank you.
Okay, members, I'm going to step back to my desk. The first case that's before us is a deferred item at the top of page 2. Mr. Cuthbertson, if you'll come forward. Case 9, Let me go through a couple of items first. No, please have a seat. I'll go through a couple things, recap, and then I'll turn it back over to you all. Members, I passed over a portion of Mr. Cuthbertson's PowerPoint that I'll bring up for you. You've got a paper version of what you're about to see as well. Okay, members, my records reflect that all parties, board members present, are eligible to participate in this case and did so at the prior case. And we had a full complement of the last board, so the 3 members who are not present, should this be deferred, if that comes forward, will need to catch up to be eligible next time. But just recapping, this case is the subject property you see is here at the northwest corner of 10th Avenue South and Lawrence Avenue. In the R6 district.
Excuse me, Joe, I'm sorry. You may have said that. So are we starting from scratch?
No, sir. This is
Okay.
a continuation from the last time.
Gotcha.
At your request, the board deferred this case to give the applicant more time to discuss with neighbors and provide some more evidence. And he's prepared to discuss that today. The subject property, again, if you'll recall, this lot has the unique retail establishment located at the northeast corner of this property that you'll see there on the aerial and both on the site plan, if my mouse would work with me. There we go. That's that structure. The existing residents here, they're proposing a second dwelling on the lot we classify it as a duplex, which is permitted in the R6 zoning district. The nature of the variance is it's set back along 10th Avenue South. The front of the structure does comply with the setbacks on Lawrence. The 10th Avenue South, because this road, as you see in the purple, is deemed as a collector street, the minimum setbacks on that street are 20 feet back. And the applicant was proposing a 10-foot setback. And just sort of review over the elevations submitted by the appellants. And then just a review of the slides that we saw last time. I think those are the final pictures. As I said, the applicant has submitted a PowerPoint. If you'll give me just a moment to bring that up, but I'll do that while you're talking and introducing the folks to your right. Before he begins, and I turn it over to him, are there any parties present opposed to case 9 present? Okay, seeing none, you'll have 10 minutes. Go ahead with your introductions, and I'll cue up your PowerPoint.
Thank you, Mr. Hargis. Mr. Chairman, members of the board, my name is Dwayne Cuthbertson. I live at 1010 Ackland Avenue. I'm representing the owners. One of the owners is to my right. Her name is Ashley Duggar, and she's here to present to you and answer any questions that you might have of the owners. And then to her right is Paula Foster. She is the president of the 12 South Neighborhood Association. She's here to support our requests and, again, answer any questions that you may have from a neighborhood perspective. As Mr. Hargis mentioned, we are here requesting a variance of the side street setback from 20 feet to 10 feet. And before I get into it, I appreciate the opportunity to come back to you with additional information and attempt to address the concerns that were raised at the previous hearing. I think that I hope you'll find that I've gathered quite a bit of information that I feel supports this request. As Mr. Hargis pointed out and as shown on this slide in front of you, this site is in the heart of the 12 South neighborhood. It's an older neighborhood in our city. It's the northwest corner of 10th and Lawrence, and the applicant is requesting the variance so that they can construct a second home on the property in a manner that they feel is consistent with and compatible with the context, the historic context of the surrounding neighborhood. They're proposing a 1.5-story building up to 26 feet tall and with a width that is 33 feet, just above 33 feet and 9 inches. We feel like this request meets the threshold for granting a variance. And reviewing the ordinance and the state statutes, it's a variance can be issued where by reason of exceptional narrowness, shallowness, and shape of specific property, at the time of the enactment of the zoning regulation or by reason of exceptional topographic conditions or other extraordinary and exceptional situation or condition of such piece of property, the strict application of any regulation enacted under this part would result in peculiar or exceptional practical difficulties. We feel like this property, as you'll see in the images on the screen, presents exceptional, extraordinary conditions. There is a historic storefront on the site that was constructed decades before this zoning code was enacted. As well, there's a historic home on this site that the applicants are working hard to restore. They plan on residing in that home, and so they have a particular interest in how this site develops out. We feel like the request is compatible or consistent with the intent of the code, which was to create, the current code was intended to create uniform streetscapes. It doesn't apply so well. We don't feel like it applies so well to historic neighborhoods where the pattern is often of variable or a variety of forms with irregular setbacks on different blocks and corners. This neighborhood, again, was built out well before our current zoning code was enacted or maybe even thought of. There are a variety, you'll find that there are a variety of patterns throughout this neighborhood, on this street, and in fact on this block that support our request. We feel like it meets the intent of the code, which is to create, preserve, promote vibrant and contextual neighborhoods. It's consistent. Our request is consistent with side street relationships found throughout this neighborhood and again on this particular block and on this particular street. We do not feel like this request would result in a detriment to the surrounding neighborhood. In fact, again, we feel like it would add value to the neighborhood and be very contextual with the pattern found in the neighborhood. Mr. Hargis, can you go to the next, I'm sorry, one more back. We submitted plans to surrounding property owners. I had discussions with as many as I could. Those smiley faces are those that have signed the petition of support that you should have in front of you. There are 14 signatures representing 15 properties immediately around and along 10th and Lawrence Avenue. Again, all supporting this request. We had conversations with the neighborhood association as well. I had a conversation with the council member who just emphasized talk to the neighbors, and we feel like we've done that. And again, we've found that we have support. There was no opposition to our request at the previous hearing. I didn't receive any correspondence, and I don't believe staff received any correspondence of opposition or concern to our request as well. The following slides will show that there are side street setbacks along this street that support our request. Every property shaded in blue has a setback that is less than 20 feet. The subject property is shaded in green on the south side of that map. Again, there is no uniform streetscape. The setbacks, they vary from as shallow as 6 feet, Mr. Hargis, if you can go to the next slide, up to 14 feet. And then, of course, there are some houses that are further back than 20 feet. Here are some images of the houses, some of the houses to the north of the site. Again, you'll find some that were at 6 feet, some were 11, 9 feet back from 10th Avenue. Which again seems like it supports our request for a 10-foot side yard setback. Mr. Hargis, next slide. This is 10th Avenue to the south of the property. And again, you'll find that there are a fair number of homes that are within 20 feet of 10th Avenue, again, ranging from as shallow as 7.5 to 14. And yes, there are some houses that are set back further. It's important to note, too, that there is an SP that was approved along this street just on the opposite side of the block immediately to the south that contemplates a significant redevelopment and I think will be far more impactful on this streetscape. If you'll go to the next slide, please. Here are some images that show some of those homes that are set back. They're 1-story, 1.5-story, and full 2-story houses within that setback. Mr. Hargis, next slide. Here's an image showing the location and relationship of the SP. It's a specific plan that was approved by the Planning Commission and Council with neighborhood support that contemplates and allows, in fact, redevelopment of the site with up to a 3-story building. The images show a 2-story building, but the SP allows for up to 3 stories and 45 feet with a 0 to 5 foot setback. much closer to the street than the houses on that same block to the north. It was centered around the idea that there was an existing building there built up to the street. We have a similar situation. We have a retail building on our site built right up to the street, and we are asking for far less relief than this SP permits. Here's an image of the elevation that was presented with that SP, and then the footprint of the proposed building. We feel like, again, our request is consistent with setbacks that are found throughout the neighborhood, on our block, on our street. We are located on a block that has a variety of setbacks. We also feel like our house at 33 feet 9 inches would be more consistent and, again, and contextual with this particular streetscape along Lawrence. Mr. Hargis, if you'll just push, the average width of the homes along this street comes out to about 36.25 feet. We're asking for relief so that we can build something just above 33 feet 9 inches at 1.5 stories, which again, we feel like is consistent with the pattern and supported by the pattern that's found there. With regard to the setback along 10th, our storefront is right up to the street. And we feel like if there would have been any impact to this particular streetscape, that storefront mitigates it. You'll also note on this block, the properties outlined in red are also corner properties. They have side yards at 6 feet each, while the interior lots on 11th are set back quite a bit further from 11th. So our request, again, we feel like is consistent with the pattern found, supported by the pattern found in the neighborhood. So in summary, we feel like we have exceptional circumstances related to the site with the historic buildings that were built well before the code was ever contemplated. Mr. Hargis, if you can go back one, sorry. The applicants are intentional about what they're attempting to do. They want to do the right thing. They want to build something that they feel adds value to the neighborhood. They're restoring the old home. They want to build something that complements it. They also intend to restore the storefront, which is, and we feel, a neighborhood amenity and will eventually add to this street. But it is a part of what we have to deal with when we're considering building something that we feel meets the character of the neighborhood. We feel like our request is consistent with the intent of the code to preserve and enhance neighborhoods, and we feel like it would not result in a detrimental impact to the neighborhood. So with that, I'll rest and I'll answer any questions that you might have.
Well, it sounds like you've done a lot of homework and
I tried.
built a very large consensus in the neighborhood. What plans do you have in the future for the little storefront, do you know?
And the owner may be able to speak more to that, but the intent is to bring it back to some sort of, right now it's non-conforming for retail use. Mm-hmm. I think the best case, what they would like to do is put in a market. A local market. That would be fantastic. It would serve an immediate need to the neighborhood. The question there is, can they find somebody who would operate a market in that small space? They would like to explore possibilities of expanding the storefront, going up, going out, but they don't want to approach this board or the Planning Commission with a definitive plan until they've had conversations with the neighborhood association, with the immediate neighbors. They want to do what's right. And so I can't tell you exactly what they want to do, but they definitely want to work with the neighborhood on this.
Do we have any other questions?
I guess if I understand it right, to get a variance, you'd need a hardship.
Yes, sir.
So what is the hardship?
Well, we feel like we have extraordinary, exceptional circumstances. We feel like the existing storefront is certainly exceptional. There aren't very many residential properties in this city, single-family, two-family residential properties in this city that have historic commercial storefronts. That we feel is our hardship. Without that that historic storefront and the historic home really dictate where and what we can build. And we feel like those are impacting the ability to build something that is contextual with the neighborhood. And so that's why we're asking for the relief to come closer to the street, is to work within the envelope that's been dictated by, again, our exceptional circumstances with the storefront, with the historic home.
I guess I still don't understand what the hardship is, in that you just got through saying you don't know what you're going to do with that building. So how is it a hardship?
Well, when I say I don't know, we don't know what we're going to do, the intent is to preserve it. It's a part of the character of that neighborhood. The owners do not want to destroy that. They do not want to demolish that building. So they want to restore it. When I say I don't know what they want to do, I can't tell you what the eventual use will be. And I can't tell you if they want to add on specifically, but I can tell you definitively that they have every expectation to preserve, they want to preserve that storefront.
May I speak to that as the owner?
Turn your microphone on,
You
please.
got
So-
it. Turn the microphone on.
We really would like to see a 1920s, 1930s storefront brought back to the neighborhood, so very similar in what you see on Belmont Boulevard. So as far as the exterior of the property, that would be our vision. Like Dwayne was saying, we've met with different people in regards to bringing a very local market into that space, which is what we've heard from the neighborhood that they would like to see. So in speaking with the neighbors in regards to this property, we've also asked, what would you like to see in the neighborhood? And we've heard market, deli, some of these things. So we can't tell you exactly what will be there because we don't have a lease signed by a tenant, but that's the direction that we are currently going in. Is that helpful?
For the record, did you introduce yourself?
Oh, I'm sorry. I'm Ashley Duggar, and I'm one of the owners of the property.
Thank you.
Thank you.
You've certainly pointed out a lot of precedent, I guess precedential oddities, if you will. But, when I look at it contextually, I look at the site and the street, Lawrence, and I don't see, the setback that you're achieving is at the sacrifice of the spacing of the houses, for one. And, also when I look, in other words, there's no houses are that close together along that street. And, in looking at your photographs, I don't know which presentation this was from, but while the storefront is an oddity, it's unique, there's a very defined line of building down that street, down 10th. Even the new things are respecting it, and this to me feels awfully shoehorned, and I think that's the context that's odd to me, that I don't see a hardship that says we could do it were it not for this or that. And I'm not sure how the building, having the building gives you something odd that says, well, we can continue to do something odd. I don't know that is a hardship per se.
I think,
Sure.
Yeah, so again, I'm Ashley Duggar. If you look at a property here like that you see in the bottom left corner at 10th and Gilmore, I think that most people in the neighborhood would refer to that as a tall, skinny house. And that is ultimately our goal, is to avoid building a tall, skinny house. What we found by meeting with Paula and the neighborhood association and talking to various neighbors is that they would really like to see a historic replica like we proposed. In the same sense that saving the Victorian was extremely important to us, we'd like to come in and build a 1920s Craftsman replica, which we believe is in the best interest of the neighborhood, as opposed to building a tall, skinny house. So in that regard, we would like to ask for the variance. And then I think, Dwayne has supported the variety of setbacks that are both on 10th and Lawrence.
Mr. Hargis, if you can go to the next slide. I'm sorry, keep going to the aerial at the end. So, Mr. Harper, I understand your concern. I would submit that we're dealing with a different criteria. We're asking for a variance of the side street setback as opposed to the front street setback. All of the properties to the north only have a front street setback that they've had to address. And it's very easy for them to do. Those lots are oriented to 10th Avenue. They're of considerable depth. They don't have historic structures that they have to work around. I would also submit that if you follow that pattern north, as soon as you jump Douglas Avenue, you've got a house that shoots to 10th Avenue. It breaks whatever pattern was being set up along 10th. I would also submit going south, you have a fairly similar situation in that you have a significant number of lots that have a front street setback off of 10th Avenue, and then immediately to the south of them, you have an SP that was approved by the Planning Commission, approved by the council, went through a significant political process, and ultimately was allowed to establish 3-story buildings up to 0 feet from the property line. And there isn't a mitigating structure in between it and the neighborhood houses to the north. We feel like we've got the extraordinary circumstances, and we feel like in this neighborhood, there is a pattern that supports what we're asking for. In this particular block, immediately to the south and to the north as well, we've got intervening houses at the opposite end of that pattern that support our request as well. You have a similar situation on the backside of this block where you have 2 corner lots, and I outlined it in one of the slides, this one. A similar situation, interior lots that have a front setback that's considerably behind 11th Avenue, but you have side streets setbacks on the corner properties, and those houses are set back at 6 feet. Those are considerably closer to 11th than the houses along that street. I would.
But 11th doesn't meet the same criteria as 10th, does it, Joey?
It's not a major street, sorry.
What was that, in what context?
But the applicant answered the question. 10th and 11th they're not categorized the same way.
11th is not a major street, but it has, by today's code, those houses would be required to set back 10 feet from 11th Avenue. They're closer than 10 feet, almost by half, down to 6 feet. They come considerably closer to 11th Avenue than do the houses on the interior of the block. And so, again, that pattern that was set up or is set up by the interior lots is interrupted, if you will, by the corner lots. But I would also submit that varying pattern is what attracts people to neighborhoods, historic neighborhoods, and you'll find that pattern throughout this older neighborhood. You'll find it throughout a lot of our older neighborhoods that are becoming so desirable that a lot of people can't afford to live there. And it's because of this varying pattern. And again, I feel like what they're asking to do with this relief is far more contextual than what the code and our exceptional circumstances would allow us to do today.
I'm going to ask our counsel to make the same point to the board that she made to me. And the reason I'm going to ask that is because I honestly didn't understand the applicant's argument, because usually when we're talking about physical characteristics of the property, it's something like narrowness, shallowness, a creek running through it. And I think they're referencing language that I've personally never focused on. And so counsel was nice enough to make the point to me, and she ought to be able to make it to all of you. So anyway.
Right. We were discussing the provisions in 1740, 370A, as well as under state law, that make other extraordinary or exceptional condition of such property that would result in peculiar and exceptional, I can't say that word today, or practical difficulties. That is also a category of a hardship. So this may not be something that comes before the board also, but it appears that that is the argument that is being made by the applicant, is not necessarily what we typically see, shallowness, narrowness, shape, but is actually falling under the other piece of both the ordinance and under state law, which talks about extraordinary and exceptional conditions.
I'm not selling here at all. I did not understand what they were saying. It's not really a characteristic of the land. It's the fact that they've got this outbuilding that's fairly unusual. So anyway.
Well, it's very unusual to the neighborhood, and that's why I asked the question about their future use, because to me, that's why this property is eligible for this variance, because this is a very rare circumstance that I've never seen before by being on BZA, and we're probably unlikely to see it in the future. I think the applicant has done a great job of gaining neighborhood support, and as they pointed out, there was no opposition at the meeting last time, and
I'm sorry. Have we closed the
no, we
public
haven't
hearing?
closed it, but I'm just,
Okay.
what I'm saying is that this land is unique, so.
And Mr. Chairman, there's a third party at the table. I don't know if they wanted to introduce themselves for the record or address anything that you.
Our neighborhood person.
Yes, my name is Paula Foster. I'm the current president of the Board of Directors for the 12th South Neighborhood Association. Mr. Cuthbertson and the owners came to the Board of Directors in December, presented their ideas. The Board of Directors voted unanimously to support their request, primarily because of their desire to keep the historical nature of the property, both the storefront and the historical home that they're renovating. We felt like it was incredibly important for the neighborhood and the different styles in the neighborhood. And I would agree that while there is current zoning regulations that dictate certain things, this neighborhood was established before that, and there are many, many variations to that particular setback from the street. And the neighborhood association felt like this was a reasonable request and would rather see a home built in the way that they are proposing than, as he pointed out, the houses at 10th and Gilmore, something that is more narrow and taller and not in keeping with the characteristics of the neighborhood. So the neighborhood association supports this request without reservation. Thank you.
Do we have any other questions for the applicant?
I guess I don't understand what bearing that other building has on the side yard request here. If that building weren't there, how would that impact the side yard setback reduction request?
Sure. If that storefront wasn't there, then we would have more depth to work with on our site. Our access to the site is dictated by Public Works. We cannot come in off of Lawrence. We cannot come in 100 feet from the intersection of 10th and Lawrence. So our access has to come from the back. With that storefront, it's impractical for us to gain access from the alley. We have to go through a parking lot. So our access is squeezed between the storefront and our proposed footprint. If that storefront's not there, we can use the additional depth to gain access, but also to push the envelope back toward the alley. And I think then we get an outcome to where we can still stay within a height that's compatible with the neighborhood while maintaining that 20-foot setback. If that storefront's, with that storefront there and our access restrictions, it really squeezes our ability to put another house in there in a practical manner.
I guess good effort, but I still don't understand the advantage or disadvantage that the building back there puts on this. Looks to me like you're overbuilding the site. So.
Mr. Chairman, I would just offer, if understanding that there are 4 members here, if the board feels like additional information could be gained and maybe be helpful to a decision, we're open to a deferral for 2.5 weeks to the next meeting in February, if that would help.
I'm not sure what the standard for deferral is, other than we simply vote to defer. But I think you might have, just doing a quick nose count in my head, I think you might have a better chance with greater numbers up here. You might be more likely to get 4 votes than trying your luck with these 4 people, if there were 5 or 6 people present.
Well, our job is really not to advise the applicant on that.
I'm not advising.
Well, if I could also just interject for a moment, the full complement of this board heard the case last time. So the 3 that are not here would need, if a deferral comes, if they wanted to participate, they're going to have to watch today's proceedings and the evidence submitted at this point to catch up to you all.
And they can still watch that if we vote. And
yeah, if it's a vote and you don't have a unanimous vote, it's put off until March the 19th as a new hearing. So just.
But that decision is yours. If you feel that you are requesting a deferral, we'd be happy to entertain that. If not, we're obviously happy to take up the matter today.
Given what appears,
Let me ask another question.
Yes, sir.
Do you have the option of seeking an SP on this property?
We could go through a lengthy SP process. It would take 5 to 6 months, and we felt like the SP is really intended for a comprehensive redevelopment of a site. We're asking for one element of relief. We intend to comply with every other requirement of the code, and so we felt like that would be killing a gnat with a cannonball, and so we didn't feel like the SP and going through that long and arduous process was it was warranted for one element of relief, particularly not knowing what we're going to do with the storefront. It may be used as it is without any element of relief needed from the board or from the Planning Commission. And so that's why we chose to come through the BZA for that one element of relief.
Well, the applicant seems to be open to a deferral. I don't have a problem with a deferral and putting it off for 2 weeks. Does anybody have a issue with granting the deferral?
I don't.
Okay. And I believe I heard 2 weeks until the 19th. So with the applicant's request, I'm going to make a motion that we defer it until February 19th.
I'll second that.
Got a motion, got a second, all in favor? Passes.
Mr. Chairman, can I just try to clarify what additional information obviously I've gotten the testimony or I've gotten the feedback from the board, but are there specific items that this board feels like they still need to see before making a determination?
Well, as a global matter, just speaking for myself, I thought the information you gave was very helpful. It certainly added a new perspective to my thought pattern. So I think the other 3 would also find it helpful. I'm not sure I can think of any new information, and I'm not the procedural guru here, but I think if you did have some new information, you could redistribute your packet to the other 3, if that makes sense.
Sir. At the least, I'll try to add some more happy faces to that.
I think you've really done your homework of getting the neighborhood association on board, which is not the easiest thing in the world in West Nashville, and also neighborhood support, as your smiley faces indicated, and the rest of the presentation was really good. I think what's missing, or what might be missing, is, as Mr. King brought up, that this old building and about the access and exactly why it prevents you from having the house the way you want it, and the entrance, the egress and ingress, and the location of the lot, the parking for that building, as you said that you want to eventually turn that back into some sort of business. So I think that building comes down to what the issues that, you haven't already covered. Everything else, I think you've really covered.
Yes, sir.
Well said.
Okay, so you're deferred until the 19th.
Yes, sir.
And I believe that I see case 11 back in the room. Would anyone have a problem with bringing them from the heel back to where they were?
Yes, I'm sure it will be just a quick update or something.
I would assume so.
Let's hear from council and see what they've.
Mr. White?
Mr. Chairman, thank you for the time that you've given to us, and I just want to go to the end of the story. I'm going to ask that the board defer this matter until the 19th, and there's folks here that may well want to make their comments. I'll try to recount what they've said and what we've done in the short time as quickly as possible. I explained to the folks that came here, I'm sorry that they came down here today. I received this call late this morning from my client. I did reach out to speak to the builder who's here with me today. And I told the client I had to be down here on a very significant matter, which was the fire hall issue, which is a great deal of your folks that were here today, but that didn't have any time to look at this matter. I would come down if it was on consent, which at one point it was, it could move forward today. And that didn't happen. There's folks that I respectfully know they have an opinion differently, and I asked for a break to go talk to them. I did. And basically, this is a variance request for 7 feet. We have a letter in the file. There's neighbors on both sides of this house. One neighbor's written a letter supporting it. The other neighbor's here with the greatest respect for him. Right now, he's not supportive. And so I explained this to the group and said I'd be willing to talk to my client to see if there was something we might be able to do in a redesign configuration to see if it might be able to be worked out. And the best summary I can give is that the immediate neighbor who has voiced opposition today has said he has no problem with that. He realizes this is somebody going to live next door to him. He wants to have the best relationship, and so I've been authorized that I could say that. There's two representatives of a homeowners association, and they do not want the matter deferred. And in fairness, I think one of them came down previously when this matter was scheduled. So that's where we stand. I'm asking for a deferral for the reasons that I've mentioned. And with respect to the request, I'm willing to discuss with my client what might be able to be done. But I knew nothing about what the variance was about until I came down here today and didn't have time to look at it because of this other issue. I've been meeting with the Fire Marshal, Al Thomas, and others on the matter that was bumped off because we had a lack of a quorum. So that's my request to defer it.
Well,
And
we have an obscure rule for the committee that the fourth deferral has to bring lunch on the day of his hearing. So I just want you to be aware of that.
we're not to number 4 yet, but trust me, my client's parsimonious enough we'll avoid that.
I'm just kidding, by the way. Or the 3 people watching us on TV.
I was likewise kidding, but that's what I've said. And there are folks here that may want to say differently, but I think I can very accurately say that the immediate neighbor on one side has written a letter in support. The other neighbor been very gracious and said, I still have a problem, but I don't have a problem with the deferral. The 2 from the HOA have said they prefer that it not be deferred. I think I've said that accurately.
Mr.
Yeah, I was going to say, so we've got a motion for deferral. We ought to hear from the people who are opposed to the motion to defer. So let's do that.
Thank y'all for coming up. And as you come forward, if you would just address the deferral portions. Thank you.
Okay. My name is Angie Henderson, and I serve as president of the board of the Belmead Highlands Neighborhood Association. This is my second time to come down here on this matter. While, we do appreciate that the neighbors that we represent have diverging opinions on that, and we do appreciate that the neighbor, Mr. Huddleston here, that is opposed, does want to be accommodating and be a good neighbor to the owner. We also recognize that adjacent neighbors are in somewhat of an awkward position because, those are the people they're going to be living next to and, want to be accommodating. But from our neighborhood association's perspective, this is our our second time to be here. We are firm in our opposition to this variance. We've talked about it some outside, and I feel that even if time is taken and this is deferred, even if there are some accommodations made and it's now a 5-foot setback instead of a 7-foot setback, we'll still be back here opposing it. So I would ask that we go ahead and hear this case today, please.
So do you feel there's no room for compromise? Is that what I don't want to put words in your mouth.
Well, I think there's certainly ample room for compromise as it relates to the design. This setback variance would not be needed, if it were not for a 4-bay garage. So I know that maybe there's some willingness by the owner to make that a 3-car garage instead of a 4-car garage. That still requires a little bit of reconfiguring as it relates to a pool, because that's another issue there. But our board is firm in its opposition because we feel that we want all owners, all residents, all neighbors for there to be a level playing field. The setback variant, or rather the setback code, is there for a reason. We care very much about the kind of the feeling of our streetscape on Cheek Road. All the homes are set back, and so whether it be 10 at first and now 7 or 4, even if I have to come back here for a third time 2 weeks from now, we would still be opposed.
But I'm sorry, I don't want to get too deep into the case, but so the opposition is to the setback because
Mr. Harper, I may stop
yeah,
you.
I'm not.
I think I want to stop you on that point for procedural, because we have not opened the public hearing. So I guess the question before this board is there a deferral? Yes or no?
And further, I would say, as it relates to the deferral, I know, the gentleman who is now going to represent the owner just happened to be here today. He was afforded the opportunity to come up here and ask for it to be put to the end of the agenda. I appreciate that you're hearing it now, but again, we've been down here twice, so that would be a third time. So in fairness, I think it should be heard today.
I was just going to say kind of the same thing. I am the neighbor. My name's Paul Huddleston. I live to the right of the said neighbor. I think the disagreement on this, or the opposition, is about the variance, and that any kind of redesign conversations we might have would be subject to finding a way for them to have a beautiful home within their building envelope. So when we come back, I think it would, if there was still a variance to that setback, we would still need to have more conversations, and we would still have a similar issue. So, like I said, he's going to be my neighbor, and I want to be a good neighbor to him, and I'm excited that he's coming to our wonderful neighborhood. So, like he was saying, I'm happy to have more conversations, but just to echo Angie, I think that those conversations will be maybe not intended for this. This could go forward, and we could have those design conversations, and it would still end up in the same place.
Sir, would you like to speak?
Thank you.
Nope.
I would just echo what they said, that the opposition to the setback is not going to change, even to the, I don't believe, to the owner next door. And if there is a redesign, then I would assume that someone would have to come down and present the new redesign. But the opposition from the neighborhood for the setback is not going to change.
And could
As
you
we
please
know it.
state
Yes,
your name for the record?
I'm sorry, Joe Hills.
Thank you.
I'm going to make an observation. I mean, we're going to close the public hearing to vote on the request for a deferral here in just a second, but I'm going to make the observation that written opposition is every bit as forceful and for the record as in person. We do, on a bi-weekly basis, read our packets, and in fact, I know there's other email on this matter. So, because I do, your citizens, you've been down here twice, and I am ultimately very sympathetic, but for everyone listening, written opposition really carries the exact same weight. So.
Understood, but written opposition for me to pull together a letter from our board, and I mean, with all due respect, that's another 30 minutes, an hour, me at my computer sending that time, I'm here now. I'm here now for the second time. I'm prepared to speak on this, and I would like to do it now.
Okay, thank you. I'm going to move to close the public hearing. Discussion.
Personally, I think we've said before and on the record that it is advisable, a lot of these cases, to get attorney representation. In this case, it's a little unique in that it suddenly turned into ability to have an attorney to represent it, and I don't think it'd be fair to the appellant nor the attorney that they're trying to do to expect that attorney to represent this appellant without some groundwork or time to get his act together, so to speak. So I understand the concerns of the opposition, but I'd have to be supportive of deferral to get the benefit to the attorney to speak with his client.
That, and we have always taken the position that further discussion among neighbors and applicants is a good thing, that there should always be room for compromise. Sometimes there's not, but we as a board have always encouraged this. So anyway.
It would be nice if there were a compromise that came back with no opposition or didn't come back, That would be even better.
So I'm going to make a motion that we grant the deferral. Is there a second?
I'll second.
Got a motion, got a second. All in favor? Aye. Passes.
Case deferred to the meeting of February 19th. Okay, the next case for the board, case 2015-14. Dan Cook, the appellant, Riverside Church of Christ, treasurer's owners of the property of 1530 Riverside Drive, requesting a special exception in the street setback. The item A listed here is withdrawn by both applicant and staff, so we will not be addressing the item A portion. And I also would like to correct for the record, this request is to construct a deck addition to the side of the church building. Not the former will be stricken from this agenda. This structure is going to remain. Church use will occur on the site. So
there's no deck. The deck's out of the picture.
No, the deck is still the issue before this board.
Okay.
The item A sort of hinged on whether a church still existed here. We've resolved that issue. So I will strike former from the agenda there. This is referred to the board under section 1712.035D, again striking the item A portion. Appellant has alleged jurisdiction under section 1740.180, item C. Give me just a moment to key up. Again, you'll see in my presentation references to the item A. We'll disregard those for the case. The subject properties which you see here, they are these parcels surrounded in red. The structure of the church building is sitting on the northeast corner of these adjoining parcels. You see the parking lot located to the south and southwest of the lot. The proposed is to rehab this structure and to use it at times for an event center. We, as a zoning code, don't have an event space designation. We've always classified it as commercial amusement indoor. I hope to, at some point, maybe with this next council, create a definitive land use for this and lay out some conditions, and it saves both Bill and Sonny prior of having to pigeonhole this into one spot or another. But they are requesting to construct a deck addition on the north side. This will be the Porter Road portion in this location. Again, this is in the urban zoning overlay, and because it's in the UZO, it is a special exception standard in which the applicant needs to prove. And just to refresh everyone here, we get these from time to time, but just look at the 12035 language. It talks about the applicant must demonstrate to the board that the proposed building setback shall not create an adverse impact on the adjacent properties nor detract from a strong pedestrian-friendly environment. That's the standard in which you are to judge the request. We do have a letter from Council Member Anthony Davis in support for the request. This area, which you see here, this patio area, it is at grade. It is not subject to the setback along Riverside. It's an at-grade concrete area. It's there. This is the front elevation they've submitted to our office. That addition you see along the Porter Road side there, covered area, and then a view, the north elevation facing south, looking from Porter Road. That area there. This is the subject property there, that deck again coming off the side. Of that building.
And what determines that the deck is on grade?
Which, on the north portion?
On the Riverside.
Oh, here,
portion, yeah.
that the concrete slab that's there is looked against the existing topography that's there on that portion of the site, and for us, concrete patios or decks that don't exceed 6 inches above that current topography there is considered an on grade and not subject to the setback. So long as it's uncovered. Now, if there's a covering proposed over this area here, which I don't believe the applicant's ever proposing, that would be subject to setback there. That railing.
It's a pretty small drawing there, but I have a hard time believing that's 6 inches above what's there given the existing condition photograph.
Yeah, I think these are railings, but of course I'll let the applicant cover those portions in his piece.
I mean, the front door is more than 6 inches above grade, and this is all. The drawing indicates that the patio goes in at the front door.
Sure, and if
That is more than 6 inches.
Right, if grading work occurs and this area is raised, I mean, that's the portion too. If this area is raised by grading from the final grade, if that slab or that patio doesn't exceed 6 inches above that finished grade.
Okay, as long as you're happy with it.
We would look at it as more of a terrace. We've seen it in some other cases on some residential structures where they fill in the area. I'm not saying that's occurring here, but I see your point as to that. Where is a grade, just on the south side of this structure, you see the retaining wall there. They're going to repair this area and that parking area to the southwest. But that deck and the portion that's before this board is right out in this general area in the south bottom right photograph. And then the view out front. So that's our case record as you have it. Members, I believe you received a transmittal from the planning department. Obviously, their comments would be restricted to the portions dealing with the deck, not any parking areas. We've resolved that issue. From a legal standpoint, I think if in case I'm trying to find their comments, whether they made any comment to the parking. And again, your letter from Councilman Davis in support for this space. And with that, I'll turn it over to you, sir, and you'll identify yourself and make your presentation to the board. And any parties present in opposition to case 14? Okay. Each side will reset the clock. We'll have 15 minutes to present your case, and I'll turn it over. Stephan, if you'll reset that clock. There you go. Okay. With that, I'll turn it over to you, sir. You'll have 15 minutes allotted to you as well. Yeah. With that.
Thank you, Joey. Thank you, Mr. Chairman, members. I've just become aware of the opposition. I don't know if it'd be appropriate to ask for a few minutes to talk to him and see what his concerns are and try to address those before we make a presentation to the board.
I think that's fine, and that would allow us to bring up case 16. Oh, so I'm sorry. Motion to move it to the heel. Is there a second?
Second.
Got a motion, got a second. All in favor?
Aye.
Passes. So we're going to hear case 16.
All right, we'll take 16 out of order. Mr. Brooks, you'll come forward, please, sir. I'll pull up the portions here. As Mr. Brooks approaches, are there any parties present other than the applicant coming forward who have interest in case 16, opposed or likewise missed? Do you? None? Okay, you're part of 15. Okay. Mr. Brooks here sitting before you, and Mr. Brooks, I'll go through this first and turn it over to you. He is requesting a variance in the rear setback. The tree density units is going to be withdrawn. The applicant's pursuing, if I understand, prior to donate to the tree bank rather than proceed with a variance, which is, as we like to talk about, it's a win-win for everybody. So So portions talking about my tree density presentation, please disregard, which we're drawing that. The nature of the request is this. You see the subject lot here. It's 1/10 of an acre in size. It's located at the intersection of Crutcher Street and South Fifth Street, just south of the Public Works Department. If you see this here, that's Public Works' office there. The existing structure, which you see on the aerial photograph, the narrow lot line in the zoning code is to be determined as front for purposes of rear setback determination. So South Fifth is the front. The proposed structure, this is the rear setback that's there now. The existing structure sits approximately 25 feet from the rear property line. They're proposing to take an area which is currently covered by a carport structure and enclose that to the property line on the west side. That western property boundary, I believe, is owned by the, I think, Public Works Department as well. But so when I say rear, I mean the left side of this photograph. This is the subject lot in its view, and as you see, I'm looking north on South Fifth Street towards Shelby here, Public Works Department here. His structure, proposed addition will be at the rear of the building here, in view of surrounding properties that are in the area. And then this area would be the addition location. This structure would be raised in a 25-foot wide addition, which you saw, with roll-up doors that have a garage door listed on it. Okay. But that's the proposed addition location. With that, I'll turn it over to you, sir. Again, just the variance in the rear setback being asked for. I did have a conversation with the councilman. I'm not sure if you received correspondence from Peter Westerholm. I wasn't sure he would speak to it. He and I did have a conversation, and I can only just hearsay say, the rear didn't necessarily have an issue with that. More concerned about the tree density issue, and he would be happy to find out the applicant's agreeing to pay the tree bank. So he's very pro-tree as a council member. So with that, I'll turn it over to you guys. And Mr. Brooks, if you'll present your case.
Am I on now? Thank you. Yes, sir. My name is Jimmy Brooks, and what I'm trying to do is, you can sort of see, I've got no place to store materials, and what I really want to do is clean the place up and make it look a lot nicer. I have talked with my neighbor, the guy who owns the surrounding property. He has no issue with it, and I just need storage so I can clean it up and make it look nicer.
It's very to the point. I like that.
Yes, sir.
And now, how long would you like us to defer your case for?
I'd like to walk away with an answer today, sir.
And so if I hear you correctly, what I'm hearing is that there are extraordinary and exceptional conditions to the property that would result in peculiar and exceptional practical difficulties? Is that what I heard you say?
Yes, sir.
Thank you. Any other questions for the applicant?
Thank you for
Dick,
being
have you
here
got-
and waiting through a long meeting.
No worries. Thank you.
All right, we're going to move to close the public hearing, and I would move that the board approve the variance because all the requirements of MCL 17.40.370 have been met, and the board finds that the unique characteristics of the property are that it is extraordinary and exceptional and would result in peculiar and exceptional practical difficulties.
I'll second that.
Okay, got a motion, got a second. All in favor? Aye. Any opposed? Passes.
All right, Mr. Chairman, since our last case is out talking, I think it may be a good time if we take a break and the board will stand in recess until those parties rejoin us. That's our final case
So
on
no
today's
Channel
agenda.
3 test pattern?
Up to those guys in the booth. So with that, the board will stand in recess. Thank you. Okay, ladies and gentlemen, board is now back in session. We'll hear, coming out of the break, both counsel here, just give them a few minutes to speak. So I believe we're ready to get back into testimony now. As a call, this case is case 2015-14 on 1530 Riverside Drive. And I will go ahead now and turn over to the appellant's lawyer and I guess fill the board in on what's occurred since our break, and then we'll get into testimony.
Thank you, Mr. Chairman, members. While on break, we didn't come to any compromise and settlement of any way because I think the concerns of Mr. Brabson's client have nothing to do with what would fall under the jurisdiction of this board, and that's relative to the serving of alcohol. And I'll let him speak to that if I've mischaracterized his statement in any way when it's his time at the table. But otherwise, I'd like to reserve 4 minutes for rebuttal to the extent that's necessary.
Okay, sounds good.
All right, Mr. Chairman, Jamie Holland represent the applicants in this case, Dan and Brenda Cook. They're the fee owners of the property at 1530 Riverside Drive, and 2 types of events are going to be conducted on the property. Some church services will continue to be conducted that they've leased out the space, but also, and while we're here today, they want to rehabilitate the property into an event hall, much like they have their other venue in Davidson County, which is over off Blakemore, called the Ruby, and that property is zoned SP. And so as a part of that process, they learned how to be good neighbors, and one of the features here is building the deck on the side. And the reason they chose that side is to be good neighbors, because on the opposing side are residential structures, and this way their most nearest neighbor would be a street. And I don't know if Joey, lost Joey. Mr. Forrester, if you could maybe go back a screen or two, or forward, sorry. One more. I thought, show the deck, covered deck on the side, and obviously that would be for patrons to go outside in inclement weather and even in nice weather and, enjoy their event, much like perhaps a wedding, a corporate event that might be there for a party, et cetera. Most of those occasions will be conducted in the evening hours. And as you can see, consistent with the code, it's being built out to the street, and the purpose there is, to engage Porter Road that doesn't otherwise exist, and there's landscaping separating the deck and the parking lot. And, obviously it's not very tall, so, it'd be subservient to the primary structure, and the primary structure will be rehabilitated and brought back to the best possible shape it could be. And pending any questions,
Mr. Holland, what is across Riverside? What is that? I mean, I can see the building. It looks commercial, but do you know what that is?
it is right across the street from that on Riverside Drive it's a plumbing company, and it's surrounded by a parking lot and an old cinder block building, and then diagonal you've got Pied Piper Eatery, and then on the other side is the other church, which is Mr. Brabson's client, and that's Family Affairs Ministry.
It's an old gas station, Chairman, that the owner uses for his plumbing business, his warehouse, I guess, office space.
Okay, and just so we're all, that's what the deck would be looking at, or that's
No,
what
the deck would be looking at the other church.
Okay.
Across Porter.
Okay.
And I wouldn't call that a retail use either, that plumber.
No, it's fenced off, actually.
Okay.
It's
Poled off.
Pulled off, yes. Got a chain around it.
Right.
Thank you.
So what about traffic and use? How often? Because it's special events, so it's not like there's regular hours. Do we have any idea? I mean, is it something they're trying to book twice a week, 7 days a week? 3 times daily.
State your name first.
Hi, I'm Brenda Cook. As far as booking it, it'd be very similar to Ruby. Most of our events are on weekends, Friday and Saturday evenings, and of course church on Sundays, both in the morning and in the evening. That's not to say there might be events during the week, but generally speaking, it's on in the weekend.
Do we have any other questions for the applicant, or should we bring up the opposition?
So, no, I just wanted to be clear that, got a whole lot of paper today, I'm sorry. So it's just the deck on Porter that we're talking about, correct?
Yes, sir.
Okay, just want to make sure, okay.
So wasn't there an insert from traffic and parking or something on this property with some?
I'm sorry, I don't know the answer to that.
You guys know?
Did anybody bring traffic and parking's report?
I didn't bring mine.
Linda sent it yesterday by email. It wasn't in the packet.
There's Joey. Joey, was there something from traffic and parking on this case?
Sorry about that. I was making a copy. Let's see. Traffic parking, they did send something. Let me read it for you. The response, Public Works takes no exception with the condition that all parking required by Metro Code and any shuttle, taxi, loading, and valet operations occur on site with no activities in the public right-of-way or operating in such a manner as to impact the public right-of-way. Any deviation from this condition will require the applicant to apply and obtain a Public Works permit. This does not imply approval of the submitted site plan, and any access and design issues will be addressed in coordinating during the permit process. And they've asked us to track them on the permit, which we have.
Okay, any other questions for the applicant? Okay, then you have got 10 minutes and 32 seconds for, oh, I'm sorry.
I guess one more thing, Mr. Chairman, and I think it would help to add for pursuant to the policy rules of this board. You know, on January 15th, we met with the Rosebank Neighborhood Association and the council member, and, you know, everybody there at the time was in support. Thank you.
Yep.
Members, I apologize. I had to step out and make a copy for Mr. Bramson, but we did receive a letter from Councilman Anthony Davis in support, and I think you have that with your packets.
I'm Frank Brabson. I'm an attorney. I represent Family Affairs Ministry, and I've done so for the last 10 years on a voluntary basis. They primarily minister to some of the housing projects and some of the schools. They're very concerned about the serving and or selling of alcoholic beverages at this event. There's so much concern about it that they were instrumental in bringing the Dollar General up the street on Porter a couple of years ago, well, about 10 years ago. And they got Dollar General to agree not to sell alcohol or cigarettes on that location. Their ministry has been trying to restore families and work in the community, and particularly with the children. And they're starting a daycare center there. And they work very closely with Stratford High School, which is only a couple of blocks from this location. They have seen the devastating effect of alcohol on the families. And they think that this is not appropriate to be just across the street from the church, where the church members are coming and going, where the children are coming and going, and it's not a proper influence that they want to sponsor. And that's why they oppose it. The events that I've heard have been expressed by Ms. Cook that these are weekend events. Well, the weekend events are very important to Family Affair Ministries because they have events going on in their church and around their church, and they have summer camps with children there, and they have programs on Saturday night, and they have church service on Saturday night and on Sunday. They just think it's in bad taste, and it's not inappropriate for the community and for the ministry that they're working in. They're not trying to be prudes, and they're not trying to be bad neighbors. They just don't believe that an event center is appropriate for this area, and particularly when they're going to be serving and or selling alcohol. Miss Pastor Glenda Sutton Gleaves has written a long letter which I read the other day and sent it to y'all the first of the week. And she's expressed her concern about the impact on the children and on the families. She would have been here today, but her mother died of cancer, and they're having her funeral today. And we didn't have time to find and solicit other people's opposition. But I told her that in her stead I would come and make a strong opposition. I do not live in the neighborhood. I live in West Meade, but I'm at Family Affair Ministries 4 and 5 times, and sometimes on a weekly basis, ever how often they need counseling or legal counseling or just voluntary work or just holding hands. I've been involved in the ministry for that period of time. I know this is a good enterprise across from Vanderbilt on Blakemore, the Ruby that they have. I don't know about their church services, whether they actually have people holding services there. That's a question in my mind. Whether they do it in Ruby's or whether they're going to do it at this place. But we know they're going to have events, and whatever those events are that involve alcohol, we're opposed to.
Sir, first of all, I'd like to say that we all are exceedingly sorry for your client's loss, especially today. And I'd also like to go a step further and say how much I, at least, and I probably the whole board, admire the work they do in the community and trying to help the children and reaching into the communities. And I do understand their point and certainly sympathetic to the overuse of alcohol, and I'm not going to our discussions, but the issue, as I see it, is they are complaining about the use for the property, and that's just really not the question before us. I mean, the legal standard that we're supposed to address is, will the proposed building setbacks create an adverse impact on adjacent properties or detract from the strong pedestrian-friendly environment? And I can see where your client definitely thinks the use will have a negative impact, but that's not the question for us. And as you well know, we're a quasi-judicial body, and we answer the questions that come to us. So anyway, I just wanted to say those things, and others may have questions or comments. Or
I was a little unclear on that myself. Well, this is item A and C?
the item A was retracted, and so we've only got the special exception on the setback.
I'm clear.
Sorry, Joey, I didn't mean to step on.
So if this special events place did not have any alcohol, would your client object to this?
Probably not.
Insofar as the setbacks themselves, do you have any opposition to the setbacks, or is this strictly the use of the building?
No, it's primarily the alcohol.
Okay.
And the serving of alcohol. And that directly impacts the people across the street.
Understand.
Do we have any other questions from the board? Okay, then thank you, sir, unless you have anything further to say.
No, I just hope we can get one vote in opposition. Thank you.
That is the math. And I'm not sure if the applicant wants, would the applicant, it's your time for rebuttal, applicant.
I don't want to belabor the point other than to say that, the property zone CL, it's a use that's permitted. And to answer his question about the Ruby, two churches in there currently, my client would love to have him come in there on Sunday. It's Ethos and C3 Church. And also the Ruby's located next door to a school. So they're ordinarily, I wouldn't be able to say this, but these clients in particular are very sensitive to the concerns of what surrounds them and do go above and beyond to be good neighbors. And with that, Mr. Chairman, I'm done. Thank you.
Move to close the public hearing. Discussion.
I think if I understand the law, and I'm no attorney, but in the alcohol thing, it does totally come before a different board or a different body than this, right? So this is strictly the...
That's correct. In order to serve or sell beer in Davidson County, one would have to have a permit from the Metropolitan Beer Board. In order to engage in the sale, storage, or selling of alcoholic beverages, you would have to have a permit from the ABC, the Alcoholic Beverage Commission, which is the state entity. So there are two additional entities that would actually have whose purview the issue of beer or alcoholic beverages would fall.
But the answer to the question is both of those are not us.
That is correct. To put another way, that's correct.
So if we were approved, this variance has no bearing on our support or anything else of the alcohol. It's strictly on the use of the thing is what I'm trying to get to, I guess.
Correct. The only thing that this board can do is issue conditions. And as we know from other cases, the conditions that this board places need to be conditions that affect the land and the property that is before you. it would be my opinion that matters such as this would be more properly before the other two boards that we've mentioned.
Thanks.
I'm going to go ahead and make a motion that, I think we already did. Okay. I am going to make a motion that we approve the special exception with regard to the setbacks because it meets all the requirements of 17.12.035D. Is there a second?
I'll second it, but I want to add with the conditions as put on there by traffic and parking or public works, is that right? Assuming that the appellant is okay with that.
Absolutely. Okay. So we've got a motion as amended. Is there a second? Oh, I'm sorry, you already seconded. Motion and second, all in favor? Any opposed? Passes.
Okay, with that, the Board of Zoning Appeals is adjourned for today. Thank you.